trial and fine amount offered by the defendant, and upon acceptance, enter judgment. Because the judgment is just one of many documents that a judge must sign, some judges use a signature stamp. Judges frequently ask whether they may direct someone else to sign by using his or her signature stamp. The Texas Attorney General addressed that issue in Opinion JM 373, which says that a signature stamp can be used by another person as long as the person does so in the presence of and at the direction of the person whose signature is being stamped. This concludes Part 1 of Authority and Duties. To begin Part 2 of Authority and Duties, let's see a judge granting deferred disposition.
Mr. Holmes, you are charged with failure to maintain financial responsibility. If you had a valid automobile insurance at the time you received your ticket, the court, after verifying proof of insurance, will dismiss the case. The verified proof is a defense to the prosecution. How do you want to plea?
I was hoping you could drop the case. I didn't have insurance.
I can't hear the facts of the case without a plea. If you had valid insurance at the time you received your ticket, the court will receive that evidence. Otherwise, I must have a plea of guilty or nolo contendere, which is no contest, before listening to any facts of the case. If you wish to plead not guilty, I will schedule you for trial.
All right, I plead no contest. I didn't have insurance when I got the ticket, but I have purchased it and I brought the insurance card with me to show you. I had hoped you would take that into account and maybe drop the ticket.
I don't have the authority to dismiss your case since you didn't have insurance on the day you received your citation. However, I can grant deferred disposition, which is a type of probation. If you decide you want deferred, I'll put you on probation for 180 days and require you to keep insurance during that time. At the end of the 180 days you have maintained the insurance, then I will dismiss the case.
Okay, how much would that cost me?
You must pay court costs before I grant deferred, and this is the same amount you would pay if you were convicted. Then at the end of the deferral period, you'll have to pay a special expense fee that will not exceed the amount of fine that I'll set when I grant the deferred. Do you want to agree to deferred disposition?
Yes, Your Honor. Thank you. I don't want this in my driving record.
In this case, the judge decided that placing the defendant on deferred disposition was better than imposing a fine. Granting deferred disposition is discretionary with the judge, but the defendant must also agree. If a defendant completes the terms of deferred disposition, the judge is required to dismiss the case. Let's talk about a judge's authority to dismiss. This power is limited absent specific authority to dismiss. If there is no statutory authority, a judge must have a prosecutor motion requesting the dismissal of a case. As you have just seen, when a court grants deferred disposition and the defendant complies with the terms of the deferral, the court must dismiss the charges. Other procedures that require dismissal are when a defendant completes a driving safety course or the terms of a teen court. If a defendant had valid insurance and the court verifies the evidence, the judge must dismiss. Or if a defendant had a valid driver's license at the time a citation was issued for failure to display a driver's license or no driver's license, the court must dismiss the charge when the defendant presents the valid driver's license to the court. A judge must also dismiss a charge of expired registration if the registration is expired less than 60 days and the defendant gets valid registration within 10 working days of receiving the citation. The judge is also required to assess a $10 fee upon dismissal of the registration charge. Other instances when a judge must dismiss include when a judge determines that he or she does not have jurisdiction of a case, or that a defendant's speedy trial has been denied when the defendant has presented a motion to the court. Similarly, on a motion to quash, which means that the defendant is asking the court to set aside a complaint because it is defective, the judge must dismiss the charge if the complaint is defective. Judges do have discretion, although not a legal duty, to dismiss charges without a prosecutor's motion for 3 offenses. They are expired registration that has expired more than 60 days, expired driver's license, and expired inspection certificate. A judge may dismiss these charges after defendants remedied the delinquency within 10 working days of receiving a citation and present proof of compliance to the court. The judge may also impose a $10 fee upon dismissal. Now we will take a closer look at a judge issuing warrants of arrest.
Judge Ronan, I have pulled the case files of defendants who failed to appear, and I have prepared warrants for your signature.
Okay, do each of these cases have a probable cause affidavit for me to review?
Officer Hill is in my office and he's finishing his probable cause statements on the original offenses. I've already prepared mine for failure to appear charges.
Okay, please have Officer Hill come in. Will you both raise your right hand, please? Do you both swear that the information contained in these statements are true and correct?
I do.
Please sign your statements and leave them with the case file so that I can review them.
If a judge determines that there is probable cause, he or she may issue a warrant of arrest. Usually a judge issues a warrant of arrest when a defendant fails to appear or is not in custody when charges are filed. If a defendant fails to appear, a separate charge of failure to appear can be filed and prosecuted. If the offense charged is a violation of a city ordinance, typically a judge will issue a summons first, before issuing a warrant. A summons notifies the defendant of charges filed and gives the defendant a date and time to appear in court. Although a summons does not arrest a defendant, if ignored, it is enforced by a capias, or a warrant of arrest, which requires probable cause. Hence, the court should have probable cause before issuing the summons. Also, before a judge can issue a summons, a prosecutor must request the issuance. Sometimes, a defendant fails to pay a fine. When this happens, the judge can issue a capias pro fine for the amount of the judgment owed. Probable cause is not required, but a judge must have sufficient facts regarding the non-payment of the judgment before issuing a capias pro fine. Although we have discussed many judicial duties in this video, there is not enough time to describe in detail every judicial duty. However, it is important for judges to know that the Code of Judicial Conduct requires judges to be knowledgeable in the law. Judges should understand that any duty that is judicial is a special grant of authority and discretion and cannot be delegated. It is judicial authority that allows courts to make decisions and judgments. It is a power that must be guided by rules and principles of law, because judicial discretion is not arbitrary, capricious, or unrestrained. Next, we will look at magistrate duties. All Texas judges are magistrates. Being a magistrate is additional power and authority. While a municipal judge's authority is limited to the territorial limits of a city and property owned by the city in the city's extraterritorial jurisdiction, magistrates have authority within the county or counties in which their city is situated. Magistrate duties are broad and are scattered throughout the Code of Criminal Procedure and other codes. Generally, a magistrate has authority to issue search warrants and order arrests for Class A and B misdemeanors and felonies. They can advise an accused of constitutional and statutory rights and set bond. Magistrates may arraign a defendant charged with a fine-only offense when the defendant has been arrested on an out-of-county warrant. This means the magistrate may take a plea, set the fine, and grant jail credit. The magistrate must return to the court of jurisdiction the plea, any fine payment, and all orders within 11 days of the arraignment. Magistrates can issue emergency protective orders and emergency mental commitments. They can also conduct examining trials, which is to determine probable cause in the case of a felony. And magistrates can conduct some administrative hearings involving license suspensions. Like judges, magistrates are required to be neutral and detached, taking a fair and impartial view when assessing probable cause. This is especially important when magistrates assess facts to determine if there is probable cause to issue a search warrant. Generally, a municipal court judge acting as a magistrate has authority to issue search warrants, except a search warrant for mere evidence. As a general rule, only municipal judges sitting in a court of record may sign evidentiary search warrants. That is, search warrants ordering seizure of non-contraband items. Now we will see a judge acting in his or her capacity as a magistrate.
Judge Roman, I just finished a forgery investigation, and I have my paperwork here for you to look at. Here is the probable cause affidavit right here.
Please raise your right hand. Do you swear the information that is contained in these documents is true and correct?
I do.
Let me read through the information. It's going to take me a few minutes, and you can wait, or I can call you when I decide whether or not to issue this warrant.
I'll wait.
Please, go ahead. You can wait in my clerk's office.
Thank you.
In this case, the offense, forgery involving a credit card, is a state jail felony. The judge has authority as a magistrate to accept the complaint, determine probable cause, and issue the warrant. The case will eventually be transferred to the district court, which has jurisdiction to hear it, but until the defendant is indicted, the magistrate has authority over the case. Next, we see a municipal court judge performing the magistrate duty of reading and explaining a defendant her rights. The defendant has been arrested on the warrant for forgery.
Miss Caulfield, an affidavit has been filed with me charging you with the offense of forgery of a credit card, which is a state jail felony offense punishable by confinement in a state jail for a term of not more than 2 years or less than 180 days, and a fine not to exceed $10,000 may also be assessed. Now I'm going to explain to you your constitutional and statutory rights. You have the right to hire an attorney to represent you. You have the right to have an attorney present prior to and during any interview and questioning by peace officers or attorney representing the state. You have the right to remain silent. You are not required to make a statement, and any statement you make can and will be used against you in court. You have the right to stop any interview or questioning at any time. You have the right to have an examining trial. You have the right to request appointment of counsel if you cannot afford counsel.
When a person is arrested and brought before a magistrate, the magistrate must take care to ensure that the defendant actually understands his or her rights, as well as how those rights work. If a magistrate has been designated by either the local county or district judge as having authority to appoint counsel for an indigent defendant, the magistrate will proceed to do so. If a magistrate has not been designated to appoint counsel, then a magistrate's responsibility to the accused is fulfilled by immediately forwarding a request for appointment of counsel to the authority designated in the county. Because this case is one that a municipal court judge has no authority to try, the magistrate will not take the plea, but will just set the bond.
Do you understand the rights I've just explained to you?
Yes, I do.
Okay. I'm setting your bond at $5,000.
This is another time that a judge may have to consider indigence. If the defendant claims to be indigent, the magistrate will have to determine the defendant's ability to post bond. The magistrate may have to consider lowering the amount of the bond or releasing the defendant on a personal bond. Also, if a magistrate determines that a defendant is mentally ill or mentally retarded, the magistrate must order an examination of the defendant by the local mental health or mental retardation authority, or by a disinterested expert experienced and qualified in mental health or mental retardation. Because the duties and responsibilities of a magistrate greatly add to the power and responsibility of a judge, municipal court judges should be careful not to be a rubber stamp for city government. Judges must take time to understand the law and standards of conduct regarding municipal judges and magistrates. At first, being a municipal judge may seem overwhelming. It helps to become familiar with the Code of Judicial Conduct and the laws that govern the procedures and practices in municipal court. The Texas Municipal Courts Education Center and the many judges who are on its faculty are always willing to assist new judges. All you have to do is call.